Hello, I'm Gene Nassif, owner of Cat's Eye Distillery and attorney at the Schindler Anderson Law Firm in West Des Moines, Iowa. I'm going to start doing a few more videos about the legal aspect of the whiskey world. So here's video number one. We're going to be talking about what's called Tater stickers and distillery liability for the Tater stickers being affixed to store picks. I'm going to begin by talking about what is a Tater sticker. A Tater sticker, as we often call it, typically is a retailer or a distributor that will affix a sticker, personalized artwork onto a bottle of a distillery's store pick. A distiller sells an entire barrel to a retailer or to a distributor. They will oftentimes create a fake label, oftentimes a parody or a comic or something like that, and then affix it to the bottles when it's sold at retail shops. These stickers oftentimes, if not every single time, are done without the knowledge or consent of distilleries. That's a key point that we'll be talking about later. Next, I want to go into a brief overview of parodies and how a parody is treated under trademark law. While I am by no means a trademark attorney, I've got a couple of points and then a case to point out here. There's a Supreme Court case that provides a pretty good analysis of how a parody may or may not infringe on a trademark. Ironically, it was brought by Jack Daniels, of all people. The case was Jack Daniels Properties versus VIP Products LLC. It was a riff on, it was something like Bark Daniels or something like that. It was a dog toy that resembled a Jack Daniels bottle, obviously being a complete riff on the Jack Daniels label itself, but having a similar but not exact name. It was a parody of Jack Daniels meant for animals. The court ruled that the First Amendment doesn't provide a first-line defense for parody products. In other words, it doesn't outright protect parodies for using third-party trademarks. Rather, it follows the same analysis of the likelihood of confusion test, even in cases where the use is expressive. This leaves what's called dilution liability, which also allows a trademark holder to recover if and only if they can claim or make a claim and prove that the parody in some way diluted the brand. Now, this liability is separate than the liability a distillery itself would have for the stickers being affixed by a third party. Distilleries generally have a duty to ensure that their labels are not altered or modified in any way to ensure that they remain TTB compliant. Our labels or distillery labels all have to go through a pretty rigorous TTB compliance test. They have to be submitted, they have to be approved, and the label on the bottle cannot be different than what was submitted and approved. There are a few exceptions. You've got the age can change, the proof can change. In some cases, you can make minor artwork changes that don't fundamentally change the label itself, but third parties, whether it be a retailer or a distributor, generally cannot throw anything additional on specifically that contradicts or that addresses those same product or those same identifiers that we need to submit to the TTB, being the name of the product, the age of the product, the proof of the product, etc. Unless a distiller explicitly instructs a sticker to be affixed, in all likelihood, a distiller is not going to have any liability. The question then comes, how do you protect yourself as a distillery should a trademark holder, for no apparent reason, send you a cease and desist letter saying that you in some way are liable for a third party affixing a label to your product, which is absolute horseshit, but here we are. A few things that you can do is to add language into your purchase orders and distribution agreements stating that the purchaser, whether it be the distributor or in the end the retailer, agrees to not affix anything to your bottles. I understand that these things happen no matter what, but so long as you are providing that language ahead of time, stating that the party purchasing agrees that they won't affix any labels or will continue to comply with TTB regulations, can absolutely protect you. Case analysis here we can go into of providing an example of this would be a company, mysterious company, bottles a 9-year 99% corn bourbon sourced from MGP. A third party affixes a sticker, this is retail/distributor, calling the pick, quote, hella corn, with a reference to a major brand's corn whiskey. From a confusion standpoint, this would be limited to the person who actually affixed the label. There is limited liability here. And the reason why is because not only is this a parody, but it is also a fundamentally different product. It would be different if the products were in the same line, whether it be a corn whiskey and a corn whiskey, right? Whether it be, in this day and age, a sourced product that may have come from the same place. You often see this, at least in today, within the last few months, in 2023 and 2024, with the onslaught of Jim Beam. So there's been a lot of 9-year-old Jim Beam that has hit the market. There have been a lot of Tater stickers, as they call them, that reference Booker's, that reference Knob Creek, that reference Baker's as well. This is a direct, this is not a riff, this would be a direct trademark infringement rather than a parody here. So another example of these Tater stickers. With that being said, unless a distillery, and there's a bunch of distilleries or non-distiller producers that bottle the product, unless they explicitly consent or request that those labels be affixed to the bottles, they really don't have any liability whatsoever. So to conclude here, a distiller is not going to be liable without in some way creating or requesting the retailer or distributor affix these labels. Furthermore, the retailer or distributor are not going to run into any issues unless they in some way attempt to portray the product of or being what the infringed is. And that becomes very difficult with sourced products, but nevertheless, in a case where the products are fundamentally different products altogether under the TTB code, a bourbon versus a corn whiskey, there's not going to be any liability. So to conclude here, one of the fun things that I'm doing in 2024 is I'm starting to do legal analysis as it applies to the whiskey world. I'm really excited to do that. I'm starting to take on a few cases right now involving, label compliance, involving other things in the whiskey industry. I'm really looking forward to this, and I hope this is one of many videos. So please join me. Keep following the videos. I do appreciate it very much. Have a nice weekend.